Eku Iluna, please rise. Ea ka'aha ho'okolo ki'i ke hano u a koa ho maila. This Honorable Supreme Court is now reconvened. Enoho ilalu, please be seated.
Velina, greetings. Makamoku puni o Oahu I kamoku o kona e ano ka koma ali'olani hale. On the island of Oahu in the district of Kona, we are gathered here at ali'olani hale. Please call the case.
Case number SCWC-22-0000740, Daniel R. Granillo, petitioner appellant, versus State of Hawaii, respondent appellee. Arguing for petitioner Daniel R. Granillo, Earl Partington. Arguing for respondent State of Hawaii, Gerald Enriquez, Deputy Prosecuting Attorney. Argument on the merits.
Aloha awinala. Good afternoon. Today's proceeding is being broadcast live on the Judiciary's YouTube channel and on Olelo. I'd like to welcome our substitute justice in this case, Judge Peter Kubota. Counsel, are you ready to proceed?
Yes, Your Honor.
The court has allowed 30 minutes for each side, and to confirm, Mr. Partington, I understand you intend to argue for 20 minutes and reserve your remaining time for rebuttal. And Mr. Enriquez, you will have 30 minutes with a 10-minute warning. Mr. Partington, please proceed.
Thank you, Your Honor. Ice water, not Starbucks coffee. May it please the court, Earl Partington for Daniel Granillo. When I first looked at this case, I said to myself, how can I argue 20 minutes? It's impossible. And then after I went through it, I realized I could argue an hour without any trouble. So I'll try to keep it short. One of the things I did want to ask the court, the New York Innocence Project produced an amicus brief that is excellent with tons of authorities that I never found. I would hope the court might consider letting me file the amicus brief and giving the state an opportunity to file anything if they would. I think the authorities in the amicus brief would be very helpful to the court. Obviously, it's up to the court. Turning to the merits of the case, on the issue of judicial notice, I would just note that in my opening brief, or my subsequent memo rather, I cited two of the many cases saying that this court may take judicial notice of certain facts. And I would note that HRE 902 sub 5 makes government reports admissible in evidence that in the sense that they're self-authenticating. So I don't believe there is any problem at all with the court taking judicial notice. Now, as I noted, the meat of the 2009 report is part of the record in this case. It's part of docket number 27. Mr. Granillo filed that, a draft, which is identical to the final report. What he didn't do is file the material, putting it in context that it was from the 2009 report. And I think the only thing the court has to take notice is that what he filed is identical to the section in the 2009 report from the National Research Council. Now, what I don't understand about the state's report, the state's memo, is they talked about that this was significant evidence that the prosecutor could have offered at the time in the circuit court. I would just note that this report is the gold standard of scientific evidence. Some of the best scientists in the United States took part in it. I'm sure since the state was nice enough to file the whole report, the court can notice who was involved in this and that this was a very comprehensive report by the National Research Council on forensic evidence pointing out the good and the bad. And this case deals with the bad. Now, I'm going to turn to the third issue. What is the standard that should be applied here? And I think it's the TIVA standard, which this court adopted in stone. As I've noticed, that excuse me, the criteria from that is that the evidence was false, that the falsity was discovered, not discovered until years later when the 2009 report was done. There was no lack of diligence on the part of Mr. Granillo, and there's a reasonable possibility the evidence contributed to conviction. Now, one of the things I want to note, if you look at their supplemental memo at page 5, they quote from the hearing below where Judge Cahill was asking me, and I mentioned that I thought that both the hair and fiber evidence was invalid. You'll see it that on page 5, twice he says right. And I understood that to mean that the judge agreed with me that both the hair and fiber evidence was inadmissible. Now, the FBI letter in this case that was sent only talks about the hair evidence. Why the fiber evidence was not mentioned, I don't know. But as you can see from the 2009 report, the National Research Council concluded that fiber evidence is no better than hair evidence. And please
and wasn't the basis of both the hair and fiber basically the same basis?
Yes. As noted in the report, the most that can be said about hair and fiber evidence, absent uniqueness, is that it comes from, if you compare the two samples, that the question sample is of the same class. And one of the problems in this case, you have no idea how large the class is. Because this was a case where involving microscopy. In other words, the FBI agent who testified merely put the two under a microscope, looked at it, and made a subjective call. And as noticed, there's no standards. And it turns out that most of this was just plain subjective. Then there
Why not apply the McNulty test? Because it was only newly discovered now that the opinions may not be as solid as one thought. Why not newly discovered McNulty test?
Well, I'm not sure I understand the question. Okay. I mean, I think here the problem with this is
The ICA applied the McNulty test for newly discovered evidence, and I think Justice Devins is asking why shouldn't that test apply instead of the false evidence test?
well, in Fukusaku, which precedes the 2009 report, this court ruled that hair and fiber evidence is well recognized as admissible evidence. So obviously there was no way that Mr. Granillo could have objected to this evidence. It wasn't until the 2009 report that we realized that the FBI had no basis for what it was doing. So certainly this qualifies, I think, as newly discovered evidence.
Mr. Partington, the Rule 40 action, though, was triggered by the DOJ letter in 2017, correct? Right?
Yes.
So why is there anything in the record to indicate why it's 8 years later, after the 2009 report, it was 8 years later that the DOJ sent its letter in this case that only dealt with the hair evidence?
Well,
I
don't know why there was a delay. I should inform the court. I was Mr. Granillo's 18th court-appointed lawyer.
Okay.
Let's just say that Mr. Granillo was a very difficult client. He filed over 150 filings in the circuit court. And I think that this case could have been resolved 4 years ago.
Well, I think the question is triggered because you said it was after the 2009 report that it became clear that the evidence, was questionable. But yet, it wasn't until the DOJ letter was sent in 2017, really, that this...
I don't think he discovered the report.
Right, okay.
Until 2017. What I'm surprised at in doing legal research, I found a number of federal cases where lawyers filed federal habeas corpus based on this evidence, but never mentioned the 2009 report. And apparently, a lot of lawyers missed this report. I purchased my own copy in 2009 because I read something about it. But I'm surprised a number of lawyers I've talked to had no idea about this report. In fact, the law library didn't even have a copy of it.
Now, the DOJ letter, as far as I can see, doesn't cite to the 2009 report.
It doesn't mention it, but it was the 2009 report that resulted in the letter because...
How do we know that?
I don't remember how
it's
I
part
know.
of it's part of my question is to understand why the DOJ letter only addresses the hair evidence and not the fiber evidence.
Well, what happened in this case, as I understand, for decades, the FBI has been sending agents out to testify in state and federal court. And as a result of the 2009 report, they had literally hundreds of cases. They had to go back and send letters out, and it took them some substantial time to get the letters out to every case that their agents testified. And I think that's partially the reason. I realize there's nothing in the record, but I'm just telling the court that the reality of what happened, because I noticed, if I may be permitted, from the amicus brief, they said 139 convictions have been set aside based on the 2009 report to date. So that's just a lot of cases, and there are a lot more out there. I know that
wasn't this, if there is this between 2009 and 2017, wasn't there this period of time when the Innocence Project got involved with the DOJ, the National Association of Criminal Defense Lawyers got involved with the DNA, and they started to wade through all the hair cases. They didn't do the fiber cases because that was a smaller species of scientific evidence, and the hair was, something that then they looked back and together looked at, and that's what they did over the several years.
That's correct. And if you look in Record 27, they also filed a copy of the agreement between the Innocence Project and the DOJ about the use of, I think it's just hair evidence at that time, because hair evidence is the majority of these cases. Part of the concern I have here in this case is in the ICA, the prosecutor argued that the fiber evidence was good, even though I had noted in my reply brief below and in my supplemental memo that the meat of the report was in the record, and they still in their thing keep saying that it's not part of the record. It is, and I think that's important. And of course, the reason I didn't do more about the 2009 report is because when I said both the hair and fiber evidence is no good, Judge Cahill seemed to agree with me. And then when he issued his decision, he just addressed the hair.
Can I ask you, and I apologize if I wasn't clear earlier when I was asking about McNulty, but is it newly discredited evidence or newly discovered evidence?
Newly discovered evidence. The newly discovered evidence is the 2009 report, which discredits the evidence given by the FBI.
So it's newly discredited.
Wait,
Yeah, it's evidence that discredits
Right.
the testimony of the FBI
Right.
agent. Yes.
All right.
Blame me, I'm getting old.
No, I'm sorry.
how is it newly discovered evidence when it was never evidence to begin with because it was false?
Well, it's newly discovered that until the 2009 NRC report came out, it was not commonly known that this evidence was no good. And considering that this court in Fukusaku, which was many years before this report, says this evidence is good, there's no way anyone could have known that this evidence was.
I understand that, but the point is, it wasn't ever evidence to begin with. How could it be newly discovered? It was bogus and unscientific and based in nothing. So this idea that we should look at the newly discovered evidence standard versus the false evidence standard doesn't really resonate, at least with me, and I don't understand why you're talking about newly discovered evidence.
Well, the newly discovered evidence is that the hair and fiber evidence was false. That's what's newly discovered.
Well, it was never evidence to begin with because it was false.
Well, yes, but considering that Fukusaku decided that it was admissible, and the circuit courts had to follow Fukusaku, it would do no good raising the issue.
I mean, it's essentially evidence that can counter the evidence that was put in by the state,
Yeah,
essentially. Right?
Until the 2009 report, there was no way to counter this FBI evidence. Remember, the FBI comes with an aura of authority, and you get an FBI agent saying that this evidence is consistent. And please note that the prosecutor argued in this case that it was a match. And I think that's a very powerful argument in this case. To say that this evidence is a match when the FBI agent didn't even testify to that, he just said it's consistent with, which the report said isn't even permissible.
So if I can ask you this, in terms of, I guess, either the hair or the fiber, in light of this 2009 report, would it be admissible for an expert to say it's consistent with, let's just take the fiber, it's consistent with the fibers in the seat of Mr. Granillo's car? Not that it's conclusive evidence that
Well,
she was there, but it's consistent with the evidence there? I mean,
Well,
with the
no.
fiber there?
because according to the report, all they can say it's consistent with a class of fibers. And without knowing how large the class is, there's no way you can make a decision on it. If the class is there are 35 fibers in the class, that means the evidence is essentially worthless. And as noted in the report, I think with one exception, there's no standard to measure against it. It's completely subjective. And I think that's what's important. The FBI just had no basis for what they were doing. And if this has been, and the problem was in objecting to this evidence, particularly in the face of Fukusaku, you were going to be overruled. But there was no way for someone to challenge this evidence at the time, because they had nothing they could point to and say this evidence is inadmissible. The FBI was saying, we did this according to our standards, and we say it's consistent with or it's a match. And how was any defense lawyer to know that that was wrong at the time? And I'm very glad that the National Research Council did this research, because I think it helps clarify the misuse of science in the courtroom. This is a classic case of where the government presented evidence that was patently false, and the defense had no way of knowing it.
So, you know, the DOJ letter specifically addresses the hair evidence again, right? You're asking us to take judicial notice of the 2009 report, which addresses in about 2 pages, I think it's only about 2 pages, that it addresses the fiber, the validity of fiber evidence, right, in general. So even if we were to take judicial notice of that 2 pages of that report, what, if I'm understanding correctly, the request is to extrapolate, for this appellate court, to extrapolate from those 2 pages a determination that all of the fiber evidence in this case was in fact
Well, the report
inadmissible.
concluded that the fiber evidence is no better than the hair evidence.
Are there, but I mean, that's one report. Are there other, you know, what else is there out there in the realm of what experts or other individuals would possibly testify as to the validity of fiber evidence? I guess that's my question. Even if we took judicial notice of this report, it's one report, right? And I know you're saying it's the gold standard, et cetera, but I mean, the record in this case doesn't provide anything else.
Well, we know now that there is no evidence contrary to this. The FBI has conceded the invalidity of the evidence. Their agents are no longer going around the country testifying to this.
Is that in the record here?
No,
Right.
but the fact that 130, well, that's not on the record either, but the point is that the prosecutor has not identified any evidence that would uphold the admission of fiber evidence. And I think that's significant. For example, they talked about, you know, this wasn't developed in the circuit court. Well, there's nothing to develop in the circuit court. This report is accepted as a gold standard evidence. It's accepted that the hair and fiber evidence is not valid. And if they thought there was some evidence out there to make it valid, they should have presented it in their supplemental memo.
I think the aspect as to the hair evidence is clear. I think they've conceded that. And given the DOJ letter, right, it was a DOJ expert who testified in this case. So given the letter from the DOJ debunking that hair evidence, no problem. The fiber part is a little different because that FBI, the DOJ letter doesn't address fiber.
Well,
so I just don't know what went into the DOJ finally deciding that they're going to make this determination as to the hair, but they don't address the fiber.
Well, the fact that the report found that fiber evidence is no better than hair evidence, and more importantly, even if we look at the fiber evidence, this in view of the report, makes it a reasonable possibility that the jury considered this. As noted in my brief, juries view forensic evidence as if you like, the most important kind of evidence. It has that aura of science. And for the state to argue this was harmless error, it's nonsense. The jury is going to look at forensic evidence and say, this proves that the complainant was in the car. When we know from the government report, it doesn't prove any such thing. And I think that's the key here. There is a reasonable possibility that the jury relied on this fiber evidence, or the jury would have relied on the fiber evidence if the hair evidence hadn't been offered. But I think to suggest that when forensic evidence is offered, that the jury doesn't rely on it, the jury does. And I note here that in State v. Baker, this court ruled that where you have take inadmissible evidence out, and the only other evidence is that of the complainant, then a Rule 40 should be granted. Because I think there's virtually always a possibility. And you'll note here from my brief, there was a lot of impeachment evidence. The state lists reasons why the evidence was harmless, but none of that evidence relates to whether or not the complainant was in the car. And I think this is important. And the fact that particularly that when the Maui police tried to take a statement from her, she kept changing her story.
Your argument is she's not a very credible witness.
Yeah, and the Maui police had to give up taking a statement. And as you notice from the other aspects of impeachment that I've noted, this is a close case. And in a close case, the defendant gets the benefit of the doubt.
In your view, if just the hair evidence is excluded and we leave in the fiber evidence, is that enough to grant your client another trial?
Oh, yes. I think without a doubt, because of the aura of truthfulness that juries give to forensic evidence. I know I had an experience just talking about fingerprint cases. I once wanted to ask an FBI agent in a federal trial years ago, what was the error rate for fingerprints? And for a long time, the FBI would testify it was 0. But I don't know if you're familiar with the lawyer in Portland who was identified by the FBI as fingerprints being found. This years ago on the Spanish trains coming into Madrid, there was a series of explosions by a terrorist group that killed a number of Spaniards. The FBI found that that this lawyer in Portland's fingerprints were on it. He was jailed for over a year before they admitted that the fingerprint analysis was faulty and it wasn't his fingerprint. So I think we have to be very careful when dealing with forensic evidence.
Well, okay, your answer to Justice Ganoza was the hair would have been sufficient. I don't know about that. I mean, but the fiber evidence showed that the woman's pants were undone. It showed that she was in that vehicle with her pants undone.
No, it doesn't.
That's the difference with the fiber evidence and the hair evidence.
No, it doesn't. It doesn't show that at all, because the report concluded that the only thing that you can determine from fiber evidence, it belongs to the same class of fibers, absent uniqueness.
Well, that's why I'm saying that there's your reasonable possibility with the fiber evidence. If it was just hair, you might not have a reasonable possibility. The fiber evidence is what put them over the edge.
Well, I disagree with that for the following reason. You can only determine that it belongs to the same class of hair. How big is the class? If the class is, there are 35 different...
Well, I understand that, but I'm talking about how Oakes testified.
Oh, yes.
Right, so you're talking about something else. You're talking about now. I'm talking about how Oakes testified and how that fiber evidence was really the key piece of evidence by the prosecution because it placed her in the car with her pants down.
Yes, correct. And that's my point. There's no way this was harmless error. And I question how the prosecutor could argue to the ICA, that this evidence was good when the 2000 report says it's no better than hair evidence. This doesn't put the complainant in the car, in my view, not unless you know how big the class is. And I think this is a key question. We don't know how big the class is. For all we know, it could be 100. It could be 2. We just don't know. And I think that is the key point here. And I think that that now that the FBI is no longer offering this testimony on hair fiber evidence is indicative of the fact that everyone now agrees, beyond the prosecutor here, that this evidence should not be omitted. Not unless we know more about how big the class is that the hair, that the fiber evidence fits
So it would
into.
be inadmissible today, so why should we let it slide from back then? Right? I mean,
Well, it's a denial of due process to convict someone on false evidence. And this was clearly a conviction on false evidence. The hair evidence, it's conceded, should never have come in. That alone, in my view, warrants setting aside of the conviction. To suggest that the jury didn't rely on that and that it was all harmless error to admit the fiber evidence, I think is nonsense. To me, this is a classic case of false evidence entering a case, innocently, I might add. I'm not blaming the state for putting the evidence in. At the time, it was believed to be competent evidence, but we now know it was false. And the Nipui case from the United States Supreme Court, and I think we have a case from Hawaii that agrees it's a denial of due process to convict someone on the basis of false evidence. I mean, Granillo has a right to have a
now
trial.
the false evidence should be material, shouldn't it?
Oh, yes, it's obviously very, very material. You know, the state relied on Vicuso quite a bit, but the false evidence in that case wasn't forensic. And to me, that makes a big difference between the two cases. Forensic evidence is dynamite, really, as a defense lawyer. If you've got forensic evidence in case, your client's going down.
Let me ask you this. As a defense lawyer, you get the evidence. You understand, I guess, where the ground rules are, where the state's going to be coming. This is all done pre-trial. We don't have trials by ambush. Does the fact that there was a suggestion of pretty powerful scientific evidence, some big shot who's testified all over the country, coming from the FBI, coming into Maui County to testify, you know, having done this hundreds, if not thousands of times throughout the country. So that person comes in. As a defense lawyer, you know that that's happening. Does that impact trial strategy, like the defendant's right to testify or not? How does this impact strategy when your strategy is based on just a false, truly false understanding of the evidence?
Well, I think any decent defense lawyer would want to research. I'm trying to think, in the 90s, did we have the internet? I can't remember now. But I don't think research by a defense lawyer would come up with anything that would challenge this evidence. And
So does that flavor the defendant's right to testify or not?
Oh, certainly. I think a defendant will be reluctant to testify in the face of forensic evidence. I mean, I would normally, I know you've been a defense lawyer. You generally have to advise your client of the power of forensic evidence in a case. And the worst thing you want to do is put your client on to say something that the jury might find he lied about.
So is it your whole right to present a defense compromised when there is false evidence, evidence that you think is true, but is later determined to be false? Doesn't that, in fact, the whole structure of the case?
Oh, absolutely. I mean, I've had this problem where a client would want to testify and there was strong forensic evidence, and I would generally advise them against it for fear that the jury and the court might find that the defendant lied and take it out on him, either in the verdict or at sentencing. I think it's dangerous for a defendant to testify in the face of compelling forensic evidence. You have a few minutes left.
Do you wish to reserve some time for rebuttal?
I'll save the rest of my time for rebuttal,
Okay,
Your Honor.
thank you.
I have tons of stuff here, but
Thank you.
time is running out.
Mr. Enriquez? You can raise it a little more. Thank you.
Okay. Good afternoon. May it please the court, Gerald Enriquez on behalf of the state. This case presents the question of how courts should evaluate the post-conviction claims involving newly discovered evidence that invalidates part of an expert's testimony. And regardless of the analysis standard you use, the ultimate question, ultimate outcome here depends on both the procedural posture of the case, which partly determines the analysis standard, and the facts of each case, absent the contested evidence.
Can we either have you speak closer or to turn up the volume? I'm having a little difficulty hearing. Thank you. Maybe try to speak more into the microphone.
How's this?
Yeah, very good. Thank you.
Apologies. In this case, well, actually, before I get to that, I know that the court had some concerns about the 2009 report and I guess its effect on the fiber evidence here. I think that part of the difficulty with allowing the fiber evidence to be taken judicial notice of is the kind of lack of a record as far as in light of the 2009 report, is the lack of a record of the reliability of the 2009 report. It is I believe it's a 16-year-old report at this point. And we also haven't had an opportunity we as in the parties, haven't had an opportunity to go through and just kind of verify that report.
But since the 2009 report, this has really been discussed nationwide, right? In terms of the unreliability of hair and fiber. It talks about fiber. I mean, yes, there's only one 2-page section on fiber, but there's 52 references to fiber because it's a similar type of trace evidence like hair evidence. And it says the analysis is just like hair evidence, except there's some additional steps sometimes. So why shouldn't we take judicial notice of and note the unreliability of fiber evidence?
I think because the report, there hasn't been an independent confirmation from the testing agency as to, unlike the hair evidence in this case, as to the validity of the analysis in this particular case. And I think, as we suggested in our briefing, one of the things that could be done, if this court was inclined to remand for further proceedings on that, is to develop that record one way or another. Because, hypothetically speaking, if this case goes back to develop the fiber evidence, and we as the state can confirm or refute the validity of the fiber analysis there, and it gives a more solid record.
I mean, didn't the report itself, though, refute the reliability of that evidence? I mean, what are you going to do? You're going to say the NRC report was wrong?
Well, not necessarily. Like I said, we would be looking into whether current testimony would be able to confirm or refute the report. Now, with that said, I understand the court's concern here about, just
Well, could you do the same thing for the hair evidence? Or are you going to say, hey, we better take a look at that hair evidence? 17 years have passed. We better look at that hair evidence again, too.
Oh, no. I mean, we've conceded that issue. In fact, part of the reason we conceded
isn't it the same analytically, especially when the NRC report said that it was hair and fiber analytically were consistent and in their findings and the conclusions of that report?
And I would agree as far as what is in the report as compared to the testimony here, that the report lends itself as, I guess, evidence of that. But in the context, and again, I'm doing this in the context of judicial notice, I think it's premature based on this current record to say that the report would support a wholesale invalidation of the fiber evidence. And I think, well, as I said, if allowed to develop it, we would figure out one way or another if we're going to, rely on the fiber evidence or not. But I think that regardless of whether you look at the hair evidence or the fiber evidence, ultimately the question will be, and also regardless of the standard of review, the ultimate question is whether absent, let's say for sake of argument, the hair and fiber evidence in this case, is there sufficient evidence to affirm the convictions?
Mr. Enriquez,
Yes.
though, you had an opportunity in your supplemental filing to bring forth any studies which discredit this 2009 report. Did you have any authority that says that the fiber conclusions were inaccurate?
And I'm not aware of any at this time. The timing of it didn't give me time to put that forward. And, and that's partly why I'm not saying that, we should completely discredit this report. I think in the supplemental briefing, I noted that this is evidence. We would just appreciate an opportunity to solidify the record in that matter, to ensure that, we're not prematurely invalidating the what may or may not be valid fiber evidence here.
Does the fiber evidence still exist?
My understanding is it does not. And I think before the 2017 DOJ letter, I think it was due to evidence retention policies, if I'm not mistaken. It was, I think, submitted forward to destruction. But I guess that goes to the effect of the evidence in this case, and then partly why we're saying that even if you discard the hair and fiber evidence, there was sufficient evidence to convict the defendant in this matter. Because all the hair and fiber evidence does is place the defendant in let me back up. The hair evidence places her in the car, and as Justice Edens noted, the more substantial evidence is the fiber evidence, right, which puts her in the car with her pants off.
But you don't look at, whether there's other evidence to support conviction. You look at whether there's if you're using the harmless beyond a reasonable doubt standard or false evidence standard, you're looking at whether there was a reasonable possibility that forensic scientific evidence contributed to the verdict. I can't imagine you would say that there wasn't a reasonable possibility, or do you?
I don't think I can stand here and say there wasn't a possibility that it contributed to the conviction, because it corroborated the CW's testimony that she was in the car with her pants off. I would say that under the specific circumstances of this case, in most of the other cases where the court has looked at the harmless error standard in the context of false testimony and things like that, it's done it with a record that indicated what the defendant's actual defense is, whether it's impossibility, alibi, what have you. It's been able to analyze it from that perspective. In this case, we don't know exactly what the defense is. We have, a variety of possibilities there.
What was argued in closing arguments?
It was essentially, as I interpret the record, that it couldn't have happened the way the complaining witness said, and the complaining witness's statements were incredible. But I think that's different from I didn't do this, or someone else did this, or a very clear structured argument as to what exactly might have happened, like on any alternatives there. Because again, all this evidence does is place her in his car, which is not illegal by any means, or place her in the car with her pants off.
Well, that's why the fiber evidence was critical, right? Because perhaps it seemed, and it was a real scattered defense theory, and I think probably because, similar to the question I posed Mr. Partington, that was the ground rule. It's just, here's some forensic evidence. What are you going to do as far as the defense? But the fiber evidence actually showed she was not only in the car. The hair could possibly show she was in the car. We knew that's later now inadmissible, but it was the fiber evidence that not only showed she was in the car, but she had her pants off, which corroborated her story. That's why that was, in my view at least, the important forensic evidence in the case that went to guilt. And if that evidence, which at least from the NRC report suggests is fake, bunk science, then why now should we, as an appellate court, sanction that false evidence and not remand for a new trial at this point?
I mean, I see the difficulty, and I recognize the court's concern with this, because essentially, if you rule in our favor, it feels like you're sanctioning the false testimony or the improper scientific testimony in this case. I think if this was a different, again, our arguments are based off the specific facts in this case. If this was a scenario where it was the defendant's pubic hair, for example, found within her pants or something like that, where it very clearly pointed to the defendant as having sexually assaulted the complaining witness, I probably wouldn't be standing here today. But because kind of the unique posture of this case, what we have is it couldn't have happened the way it did, the essential defense theory that the witness is not credible. And it goes to, I guess, not knowing exactly what might have happened there. And in the courts in general, we have the harmless error standard because I think courts recognize that not every scenario where you have error or false testimony or something like that should result in vacating a conviction or remanding for a new trial. And I think this is one of those very limited scenarios where this does not require a new trial based on the other evidence that kind of corroborates the complaining witness's testimony.
But I thought under the false evidence, or I understand under the false evidence scheme, and that if it's material, then that false evidence impacts the due process right to a fair trial. So if you, aside from what you think about the evidence, if it's material, it pretty much violates the right to a due process.
I mean, the materiality, at least as I understand the false evidence or harmless error standard, goes to whether it's actually cumulative or not, whether this evidence really matters, similar to the way the IC approached this case with the McNulty standard. But I think even if the evidence is material, you still have that final question, I think, which is kind of what we're arguing here, is you still have to look at whether there's a reasonable possibility that this contributed to the conviction in this case. And I think one of the things I've noticed over time is under the harmless error standard, I think both attorneys and the courts kind of look at the reasonable possibility standard as something that's almost like a hair trigger type analysis, right? If you have any kind of error, in this case, false testimony, that automatically means, vacating the conviction there. And I think the reasonable part of that is sort of what maybe we've moved away from. That's just my personal opinion on that. But, I think ultimately, the structure of the test indicates we have to look at whether there's a reasonable possibility, an actual reasonable possibility, not just any possibility.
So let's say a new trial is ordered in this particular case. Is there any way that hair and or fiber evidence still can get into the case at a retrial?
I think technically it could, as I understand it, and per the DOJ letter and I think both the 2009 report, the underlying principles for the hair and fiber evidence haven't been invalidated. It's just, and it's noted in the DOJ letter, it's the examiner's specific opinion, that you can particularize hair and fibers. But microscopic examination, spectrometry, I don't know if I'm saying that right, all of those principles are still valid. Now, as to whether it would make sense from both a resource and, given what happened here, like from, I guess, a trial strategy perspective as to whether we would introduce that type of evidence or not, I don't know.
Like Mr. Partington was saying, you got to look at how big the class is, and you got to perhaps look at other issues in terms of how material, perhaps, that the evidence is. And specifically, I'm talking about the hair because, that's the one that has been clearly addressed by DOJ. Even if you assume the fiber evidence has the same issues, I suppose that's the same type of concern would be there in terms of whether you would seek to admit that type of evidence and whether it is really material or not.
I think that's correct. I think the materiality of the evidence would be an issue, whether, at this level or, on retrial if the court demands for that. I don't.
Could you speak into the mic instead of speaking up?
Sorry.
Please, thank you.
There. I think that the hair evidence or the analysis may have some basis there. I don't know. Again, this is almost 30 years later. I don't know what a current examiner would say for how this fiber would work, or even if they could. Like I said, as I said, I don't know if I don't think that the evidence is still around to be tested there. And I think
if the evidence was available, it's really, the evidence might still be relevant and material. It's just the ultimate opinions may have to be pulled back a bit. Isn't that really what you're trying to say?
yes, I think that we definitely probably wouldn't. We wouldn't be asking an expert to say to particularize hair and fiber evidence, because I think that would, again, unless there's some other evidence that occurred between the 2000, let me take a step back. Unless there's been some other scientific standards or other supporting findings between 2009 and now to say that you could make those particularizations, which
Right, because opinions just exceeded the science.
Yeah.
That's the whole problem with this.
I think so. And we've conceded that the FBI has told us.
And I understand, I actually appreciate that. But, I want to ask you on this DOJ FBI letter, was there any indication that it was based on anything other than the NRC report?
Not that I'm aware of. I mean, when you look at the letter and you look at the portions of the testimony they're talking about, there doesn't seem to be any mention of the fiber. And I guess
No, but the basis of the report as it related to the hair analysis, was there any indication it was based on anything but the NRC report?
I don't even think the report, the letter, I could be wrong on this, but I don't think it references the 2009 report. I think it just says that, it may reference the 2009 report just as a general fact, that it happened, but it doesn't say necessarily that the opinion and analysis prompting the letter is based on that particular report. I don't think that's anywhere in the record there. And I think in part too, that's another reason why, judicial notice of the report to invalidate the fiber testimony on this record at this procedural stage is kind of premature, because we don't know exactly.
Invalidate this fiber testimony. He testified when he was asked whether the CW was in the car with her pants off and her panties exposed, and he said yes.
Correct.
How could that not be false evidence under the 2009 test when you read that report and it's very clear that there's no way you can get to that type of specificity with respect to fiber evidence?
Right, and that's why we're saying the report and its conclusions are evidence that he testified falsely. We're not denying that is distinctly a possibility. I am not a forensic expert. I don't have the kind of science background that would lead me to, I guess, confirm on my own that the report is correct in the context of this case, and that's where the caution comes from. I don't want to stand here and say that the fiber report is bad without having some kind of confirmation to solidify that record there. And that's the only thing I'm saying. I recognize that you disagree with me, but.
Okay. In terms of the 2016 report indicates that the FBI decided to go examine like 3,000 cases of hair evidence first, right? And they started going, and then they discovered that there was huge problems, so they started notifying people. And then, just before that 2016 report, they said that they were going to be doing a random sampling of other types of evidence like fiber or bite mark, all of these discredited types of forensic evidence. And so there's no indication that they were going to be doing a study of all cases in which FBI testified with respect to fiber and or bite mark or shoe or tire tread evidence, all of these types of evidence that have been since been the validity has been seriously questioned, right?
Yeah, I don't think the record would support saying otherwise. I think the facts kind of speak for themselves. There is nothing in the record to indicate this was a comprehensive review dealing with fiber and everything else. The letter was specifically addressed to hair evidence. And I mean, and that's partly, again, why, without repeating myself too much, why we're not saying we're going to just rely on the fiber evidence completely. I think the only reason we're talking about the fiber evidence, we as in the state, we're talking about the fiber evidence here is because that's not properly before the court at this point. However, we do recognize that,
You're not conceding that his testimony that this fiber evidence showed that she was in the car with her pants off, that was not false testimony, false evidence under the 2009 standard. You're not willing to concede that?
Not at this point on this record.
Okay, thank you.
And all we want is an opportunity to confirm that. I see my time is getting kind of close here.
Counsel, I mean, this case has come alive for a couple of years now, so what's been going on to try and verify this?
If memory serves, we tried to contact the FBI about the fiber evidence. We didn't hear a response back for it. But and I think as Mr. Partington sort of noted, that the fiber evidence wasn't really, we didn't understand it to be an issue that they were contesting until the reply brief. And so thus we haven't looked into it that far there. But I think overall, just to kind of, I guess, talk about the fiber evidence a little bit more before moving on is, our position is that even if you throw out the disputed hair and fiber testimony, we still think that on this record, there's sufficient evidence to sustain the conviction there.
We're not discussing a sufficient evidence standard. Obviously, there's sufficient evidence based on her testimony. But if we are going to go with a false evidence standard, then the issue is whether or not the evidence is material if there's a reasonable possibility, likelihood that it contributed to the conviction. And can the state really argue that there is no reasonable, if that's the standard, there's no reasonable likelihood that this hair and fiber evidence contributed to the conviction?
Well, as I said before, I think that we can say, with the emphasis on the reasonable portion there. As I said, I can't stand here in front of you and say that there's no possibility that it contributed to her credibility, because it contributed, as Justice Evans noted, it contributed to her being in the car with her pants off. But that in and of itself is not something that...
Obviously, if this is not an innocence case, this is a whether or not a new trial should be ordered case, right?
Yes.
So we're not really talking about sufficiency of evidence without this evidence. We're really talking about reasonable likelihood.
Yes. We can agree on that at least.
Thank you.
Yes. I guess, well, before I move on, does the court have any other particular questions they wanted to ask? All right. Well, I guess one of the last things I sort of wanted to talk about was our initial position as far as the standard in this case goes, which was the McNulty standard. We think that should be the analysis standard here. With that, I think it would probably, I guess to address one of the court's questions to Mr. Partington earlier, it would require some slight modification both to analyze it in the context of the original trial. I think that's appropriate here. And also to reflect the discovery of the controverted testimony Speaking to the other elements that we're not really disputing here, when they discovered it, things like that. We do think that that's kind of the McNulty standard to be the most appropriate given the nature of this procedural posture of this case and the nature of this type of claim that arises, decades after the fact, well after the direct appeal, Rule 33.
I'm sorry. Could you speak into the microphone, or could we raise the volume? Sometimes your voice trails, and I'm having a lot of difficulty here. The sound over here is not as good as out there. So please try to speak into the microphone, or please turn up the microphone. Thank you.
My apologies. Is this okay?
I can hear you now.
Okay. I think for the procedural posture of this case and the history, the McNulty standard with the somewhat higher than the harmless error or false evidence standard is appropriate here because it balances, as noted in our supplemental brief, it balances the interest between ensuring the integrity of convictions, allowing defendants the reasonable and fair opportunity to contest possible wrongful convictions, while at the same time preserving the interest in the finality of convictions and ensuring that procedurally, their defendants aren't incentivized to delay bringing claims and such. But again, regardless of which standard you go with, our position is still that the evidence in this case, in and of itself.
I'm really having difficulty understanding this delay argument. You're saying the defendants would be incentivized to delay bringing these types of claims to set aside their convictions when they're in custody?
Potentially, depending, and I think it's more of a hypothetical concern than anything. I'm thinking primarily in terms of being aware of newly discovered evidence at the trial stage, and then waiting to see how the verdict works out, whether in their favor or not, and then raising it later should that happen. And that's probably the primary concern there. It is not the primary focus, I think, of that analysis there, but we do think that is a factor to consider. And well, I think that is all I have to say. So I guess in conclusion, I would say that, again, based on our arguments, we feel that the circuit court's denial of the petition in this matter should be affirmed for the reasons we stated. Thank you.
Thank you. Mr. Partington, your rebuttal.
Thank you, Your Honor. I would note primarily that the burden is on the prosecutor to show beyond a reasonable.
Could you lower the microphone?
Yes, I'm sorry.
That's all right. Thank you.
The burden is on the prosecutor to show beyond a reasonable doubt that this evidence did not influence the jury result in the jury verdict. And I think they have failed dismally on that. Also, I'd mention, obviously, the finding in Fukusaku and its progeny that this evidence is competent obviously has to be corrected. I think that the answer to their argument, if I may read from page 161 of the report, talking about analysis of fiber evidence. It says, fibers associated with a crime, including synthetic fibers such as nylon, polyester, and acrylic, as well as botanical fibers such as rami or jute, which are common in ropes or twines, can be examined microscopically in the same way as hairs, and with the same limitations, referring to hair. Fiber examiners agree, however, that none of these characteristics is suitable for individualizing fibers, assuming a fiber from a crime scene with one and only one source, that fiber evidence can be used only to associate a given fiber with a class of fibers. If the hair evidence is inadmissible, under the report, ipso facto, the fiber evidence is inadmissible. There's no way around it. Both suffer from the same defect. the only thing that can be said is that hair or fibers come from a same class of hair or fibers. And without some evidence of how large the class is, there's no way on earth that the FBI can testify as they did. And I think, as you have questioned, Your Honor, that it's very clear that this evidence was decisive. And the prosecutor argued it. The hair and fibers were the same. How they can say that this was harmless error is beyond me. This is just a classic case of totally false evidence coming in that contributed to the verdict in this case. And I believe that the court has no choice but to set aside the conviction. If you have any questions, I'll be happy to answer them, but that's really all I have to say.
Thank you. There being no further questions, this court takes this matter under advisement. Thank you to the counsel
Thank you.
for their arguments.
E ku iluna, please rise. Ua ho'oku'u ia mai ne kea aha ho'okolo ki iki hanohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.